I appeal, who for convenience I will refer to RT. My learned friends, Mr. Kennelly, Queen's Counsel, David Glenn and Jessica Boyd appear for Ofcom. As my lords know, this appeal from the Divisional Court concerns a challenge to Ofcom's decision of the 20th of December 2018 that several programmes...
Mr. Krasinski, you've got a bit of competition outside.
I do.
So if you could keep your voice up, we'll all be able to hear everything you say.
I'll endeavour to do that, my lord. I'm normally told in chambers that my voice is too loud and nobody else can hear themselves, so I'll try and mimic that now.
Well, we're not trying to hear ourselves, we're trying to hear you.
So, as my lords know, this appeal from the Divisional Court concerns a challenge to Ofcom's decision of the 20th of December 2018 that several programmes broadcast on RT between March and May of that year breached the due impartiality provisions of the Broadcasting Code, following which Ofcom imposed a £200,000 sanction. After some introductory comments, I'm going to start, if it's of assistance, with a short summary of our case on the principal issues in the appeal. I'll then take you to the key sections of the Ofcom breach decisions under challenge, which can be found at the final tab of the core bundle. I'll then address the legislation under the 2003 Act and the code, and also the guidance on that code. I'll then develop our submissions on ground one, which, as you know, concerns the relatively narrow question of statutory construction as to the relevance of other programmes broadcast on RT. And then I'll finally address our submissions on ground two, including by dealing with the Article 10 case law. My lords, at the start of her speech in the Animal Defenders case, Baroness Hale said, and I quote, "There was an elephant in the committee room, always there but never mentioned, when we heard this case." The elephant to which she was referring was the dominance of political advertising in the United States, upon which enormous sums of money were spent. What might be called the elephant in the room in this case is the fact that the state of UK-Russian relations is, and perhaps more importantly was, at the time of Ofcom's decision, less than ideal. And it is no secret that some people, including members of Her Majesty's government, have regarded RT as little more than a Russian state propaganda vehicle. But in that context, I hope, in fairness to my client, I can mention just two background matters, both of which are uncontroversial common ground. First, that even though, following the events in Salisbury in March 2018, Ofcom said it was considering whether RT's licence should be removed altogether on the basis of its association with the Russian state, making it not a fit and proper person to hold a broadcasting licence. Ofcom ultimately did not find that RT was unfit to hold such a licence. Second, that prior to the period of Ofcom's investigation in March to May of 2018, RT's compliance record with the Broadcasting Code was not materially out of line with that of other broadcasters, and since 2018 there has not been a single finding of breach against it of any of the provisions of the Broadcasting Code as to impartiality, accuracy or otherwise. And in any event, and regardless of those matters, RT is obviously entitled to the protection of Article 10, notwithstanding, indeed precisely because some of the views expressed in its programmes, including on the controversial subjects addressed in the programmes in this appeal, are clearly not popular in the UK. But as Lord Justice Sedley famously put it in the Redmond-Bate case, which I'll come back to, free speech includes not only the right to speak the inoffensive, but also the contentious, the heretical, the unwelcome, and the provocative. Can I now turn to summarise the main features of our case? As my lords know, there are two issues in the appeal. The first is the narrow question of statutory construction of the Act and the Code. The question is this: in deciding if a programme meets the standard of due impartiality, is Ofcom precluded?
Can you take that a bit more slowly?
Yes.
In deciding if a programme
meets the standard of due impartiality, is Ofcom precluded as a matter of ordinary statutory construction from taking into account the fact that the audience for that programme will also have access to other programmes broadcast on the same channel, on the same subject matter, including on the same day.
On the same channel, on the same subject matter,
Including
on the same day. So you're going for any programming on RT.
That's the question arising under issue 1.
I mean, can I just put to you what I identified as the first issue,
Yes, madam.
which is whether the Divisional Court was wrong to hold that the 2003 Act precluded Ofcom from taking into account other programmes broadcast on RT that were not explicitly linked to the programmes over the same period, addressing different viewpoints on the subjects in question.
My lord, I would be, with respect, entirely content with that formulation.
Lovely. Right, and the second?
And the second, and frankly more important issue, is whether Ofcom's decision that RT was in breach of the due impartiality requirement for the programmes unlawfully interfered with the Article 10.
Take it too fast. Whether Ofcom's decision that RT was in breach of
The due impartiality requirements for each programme unlawfully interfered with the Article 10 rights of RT and its audience.
Of RT and...
Its audience.
Right, okay, that's a slightly different formulation from mine. Maybe you'll not disagree with this either, which is more simply, the second issue is whether the Divisional Court was wrong to hold that the breach decisions, that's the 6 decisions, did not infringe Article 10.
I'm again entirely content with that formulation.
Okay. Yeah, but it is, your formulation is helpful because it sort of tells us where you're going.
My lord, on the first issue, as you know, our case in summary is that nothing in the Act or the Code precludes Ofcom from taking into account, as part of the relevant context, those programmes. And by those programmes, I'm going to adopt my Lord's encapsulation of what I mean by that.
Yeah.
I said, and I adhere to the description of this being a narrow dispute, and I say that for this reason. It's common ground that under the Act and the Code, Ofcom can, and indeed must, take into account the content of programmes shown on the same channel immediately before and after the programme in question.
Adjacent programme.
What did I say, sorry?
Immediately before, you said. It's adjacent is the word.
Adjacent, yes. Again, my Lord is right, adjacent. Immediately adjacent, which would encapsulate before and after, I think.
But that wasn't common ground with the Div Court.
No, it was not. It's common ground in Ofcom's broadcasting code. Because, as I'll show you, and as you have no doubt picked up, the code in defining context, which is by reference incorporated into the definition of due impartiality, refers to programmes before and after.
And it was part of the Ofcom decision.
That was indeed part of the Ofcom decision.
But the Divisional Court did not refer to that.
My Lord is right.
And was it common ground before the Div Court? You were both there, I think, were you?
Yes, we were, and it was.
So they went, you say, a bit off-piste.
I do say that.
Does it matter? Because Ofcom took it into account anyway.
My learned friend says it doesn't matter. And I accept I have to go further and to show that Ofcom's, if I'm going to get effective relief, I need to show that Ofcom's decision was itself unlawful in the sense of being inconsistent with what we say is the correct interpretation of the legislation and the code. I don't accept Mr. Kennelly's further submission that if Ofcom was wrong about that, it still doesn't matter because our case stands or falls on Article 10. I accept entirely that Article 10 is the more important part of our case. But if Ofcom misdirected itself as to the scope of what it could take into account, then for that reason alone and independent of Article 10, its case, or rather its breach decisions, are vitiated by an error of law.
Yes. I just want to apologise for this extremely noisy keyboard. I've actually, last term, had a keyboard that was quiet, specifically. In fact, I bought it myself because I was provided with this very noisy keyboard, but I will have it changed when we break at lunch.
Either I'm so concentrated on my own voice that I can't hear it, or my ears are so old that I can't.
Well, no, and also I'm closer to it.
You are closer to it.
But, noisy keyboards are one of my phobias.
I won't bore you with this anyway.
Yeah. Keep going.
I'll keep going. The second issue, my lords, which is, I'm not going to repeat it because I don't have written down my lord's formulation of it, but my lords know what the second formulation is. Can I identify the key elements of our positive case on it, ground 2, and then summarise what we say are the main errors in Ofcom's decision and in the divisional court's analysis? 1. Given the importance under convention case law attached the right to political free speech, the scope for regulatory interference with that right is narrow. And to protect the right, a regulator and the courts need to undertake, quote, a close and penetrating examination of the factual justification for the interference to determine if it is proportionate to the legitimate aim pursued. Two, in this case, the legitimate aim which Ofcom says it was pursuing, or at least one formulation of that aim, was to protect the audience from, and I'm quoting here from a learned friend's skeleton argument, quote, the potential harm which is caused to specific viewers of the broadcasts as a result of their exposure to partial broadcasting on matters of important political and public interest.
Yes.
3. Thus, in assessing whether regulatory action was proportionate, we say it was necessary for Ofcom to consider and for the courts themselves to consider the extent to which, if at all, the RT audience would in fact have been harmed as a result of their exposure to these programs. Four, to carry out such an assessment, in our submission, one must carefully assess the content of the programs themselves, the likely audience expectation when watching them, and importantly, as well, the reality of what the audience will have been aware of on the issues discussed in the programmes from other major TV news channels, as well as from other programmes broadcast on RT.
Any other TV channels?
My Lord will have picked up in our skeleton to the reference to the dominant media narrative. And one of the submissions that I'll be making in due course is that although there might be other circumstances in which there is no dominant media narrative, Ofcom have not disputed in these appeals that there was such a narrative and what it was. In other words, it is not disputed, because it seriously could not be, that if you turned on the BBC or Sky or Channel 4 in the immediate aftermath of the poisoning of Sergei and Yulia Skripal, those channels were broadcasting very clearly the dominant view promoted or adhered to by the UK government, that it was the Russian state that was responsible for those poisonings.
Well, they weren't. You're saying they were broadcasting that view exclusively. Were they not referring to the Russian government's reply?
Well, they may well have been, but our central case on the dominant media narrative is that it is unrealistic to think that a viewer watching one RT programme would have been existing in a silo and would not have been aware that the UK government blamed Russia for that incident.
What's the evidential foundation of that? I mean, let's assume that what you say is true about what was actually available.
Yes.
Often in these cases, one gets the difficulty that there's no evidential foundation for any assumption or conclusion about what readers or viewers do. I mean, it's often said in media cases, well, this information was out there, look, it was published in the Telegraph. Well, we're looking at the Mirror or the Guardian, and we don't assume that everyone reads everything or that everyone watches everything on TV. So what's the...
My lords, I will show you later the evidence that was before the court in the form of Ofcom's own research paper concerning the number of news channels that most people watched. We did not have in evidence before the divisional court a conspectus of all the content of all the other channels broadcasting on the days in question.
No, I'm just talking about audience overlap, really, rather than what the content was. Let's assume you're right about it.
Well, I'll show you evidence of audience overlap in due course, my lord.
And are you focusing exclusively on broadcast news?
Yes, I could, in principle, broaden my submission to non-broadcast news in the sense of looking at what's on the radio, what's on...
I mean, if you're looking at audience expectation, I don't know what the evidence would be, but a lot of people get their news from a variety of sources.
And that is indeed
every
the evidence.
day.
Absolutely. And that is indeed the evidence before the court. As I'll show you when we get there, the New Zealand code, and I'm not saying that there's only one allowable standard, but by way of comparison, the New Zealand equivalent to the broadcasting code requires to be taken into account when the balance standard is being assessed, the content, the likely viewer knowledge from a whole variety of media sources. It's not confined to other TV news. We've confined our submissions, in this case, to the content of other TV news for a variety of reasons. I could go into them, but that is the limit of our case.
Your attack is on what Ofcom did in this case, not upon the regulatory regime as a whole.
It is.
Well, you say that. Well, there are several points in your... You seem to stray into an attack on the wider point.
Well,
the regime as a whole.
To be clear, my lord, we do not say that the due impartiality standard is of itself incompatible with Article 10 of the European Convention on Human Rights.
No, I know you say you don't. But the problem is that the world has changed in the last 20, 30, 40 years, as you point out in your historical argument. And as is pointed out in the paper to which you've just referred, 58% of people get their news from the internet, and only 60-something get their news from television. And there is overlap, of course, between those two figures. And there is no due impartiality requirement on the internet. And therefore, when you're asking the question whether the interference with the right of freedom of expression is necessary in a democratic society in order to pursue the legitimate aim of being necessary to protect others, the rights of others, which I believe is the correct question under Article 10.2,
Yes.
you might say it's not necessary because most people, or many people, get their news from the internet, and there's no such requirement there. So why should there be a requirement here? Now that would be a revolutionary submission, not made by you, I know, but you are saying that the expectation of viewers is relevant. You are saying...
Which is what the code says itself.
I know it does, and so does the statute. And you are saying that it is relevant to consider the other programming on other channels that people will have access to, which is strange if you're not considering the fact that people have access to biased internet news content and on the evidence take up that opportunity. So you see how I ask myself why, when the correct question is asked, is the interference with the right of freedom of expression necessary in the interests of a democratic society and to protect the rights of others, I don't see how you can limit the answer to that question in quite the way you do.
Well, can I answer that question in two ways, Milo? The first is to refer to the reasoning advanced in the animal defenders case, relied upon by my learned friends and by the divisional court, to say it's particularly important that the due impartiality requirement exists for TV as compared to the internet, because
A long time ago.
I accept and aver that very point. But my lords described the wider submission as revolutionary. We thought...
Well, because it would destroy the regime.
Because it would destroy the regime. So we thought carefully, as you would expect, about the scope, stroke, ambition of our argument. And we've limited it in the way that we have.
And the question to you, Mr. Krasinski, which I know you know, is why have you limited it to other programs on other broadcasting medium, which is totally illogical if that's not mentioned in the statute or the code. And anyway, the statute and the code do not specifically give you the answer to Article 10. So isn't your argument logically extended as I've suggested? And then, unfortunately, it leaves you in the position probably, or possibly, if Mr. Kennelly will say definitely, trying to prove too much.
Well, part of the reason we have not gone that far is because we don't have the need in this case to prove that much. As I mentioned before, the New Zealand Code does go that far. No one would suggest that the New Zealand Code is per se irrational. I gave my lord one answer to the question. And another answer to the question is that although we don't say that the due impartiality standard is of itself incompatible with Article 10, nor do we go so far as to say that Article 10 requires necessarily all knowledge out there in the ether to be taken into account, whether broadcast on YouTube or Facebook or Radio London or other non-TV.
You make it sound as if real people don't look at YouTube
No, no.
or Facebook, but they do.
They do indeed. But can I just pause for a second, my lord? If my lords considered that, for the reason you have just given, it is entirely artificial to exclude from consideration, under the due impartiality standard, those other sources of news content, then the fact that we haven't gone that far would not mean our case failed. It just means it would succeed and might have gone further than it has done.
I think it means that when answering that question that I've posed and will continue to pose, because it is the question that this court needs to answer, you need to be realistic and not just be confined by the argument. And the realistic position is it still justifiable in the current environment to, under the legislation, to restrict, to have a requirement for due impartiality on a small part of the news digested by individuals? And Mr. Kennedy will say, absolutely it is, because there are real differences between the broadcast media and YouTube and Facebook and other types of media. But you can't, my point is, I'm not sure you can avoid considering that question, because you've got to answer the question, is this restriction necessary in the interests of a democratic society in order to protect the rights of others?
My lord, I would accept that. There's also another matter that
which is not a bounded decision. You see, I think some of the argument in this case has confused the statutory construction question, which is all very interesting, and you know, I love it, but doesn't actually tell you the answer to the Article 10
question. I would respectfully agree there has been a degree of confusion between the two, including with respect to the divisional court.
Yes, I agree.
The other point you'll see we've made in our skeleton is not just by reference to the availability of other news content on other non-TV channels, but also the proliferation, I think my lord had this point in mind a few moments ago, since the requirement was first enacted in 1954, of news on television itself. So in 1954, when the standard was enacted in the Act of that year, there was the BBC, and then there was ITV. And there is a world of difference between a situation where you basically switch between two channels.
Well, and also you ceremoniously, I'm pleased to tell you I wasn't born in 1954, but shortly thereafter, you ceremoniously sat down to watch the news at 6 o'clock, or 10 o'clock, or whatever it was, and that was all you could see.
Yeah.
And the television wasn't even broadcast during the daytime, let alone 24-hour news channel.
I remember watching the test card avidly, my lord.
Me too. On a very small screen,
Yeah.
Mr. Brzezinski. The one we had was 8 inches. Like that.
My lord, can I, unless there are any further questions?
Yeah, I'm sorry.
No.
I've taken you out of your...
No, I'm happy to be taken in any direction
Shut up.
that is helpful. Can I turn to analyse what we say are the main errors in Ofcom's approach,
Yes.
and indeed in the Divisional Court's judgment? Nowhere in Ofcom's breach decision, and nowhere in the Divisional Court's judgment, is there any analysis of the specific harm likely to be done to the viewer by watching any of the programmes in question. Still less a rigorous factual assessment of that question. 2.
I mean, It's a very difficult thing to expect.
Well, can I test that in this way, my lord? There would have been entirely possible for the Ofcom breach decision and for the Divisional Court's judgment to conduct this analysis. Well, yes, George Galloway in the Sputnik talk show programme advanced a number of theories about why Mr. Putin would not have had any interest in the assassination of Sergei and Yulia Skripal, and why, if he did, it would have been a silly thing for him to do it at the time that it was done, at around the time of the World Cup. The Ofcom decision could have said, well, there's a serious risk that people will be misled by that view. But hang on, are they really going to be misled by that view when on every other channel they're seeing all sorts of arguments the other way concerned with the link between Novichok and Russia, etc., etc. Overall, although, I'm paraphrasing now, we don't much like the content of the George Galloway programme, there is no risk that anyone was misled by this. And therefore we don't consider regulatory action interfering with RT's free speech rights to be justified. But there is simply no such analysis. Rather, what they do is they say, well, we recognise your points on audience expectation, we hear what you say about the other programmes which form the implicit background to this programme, but the standard says what the standard says, you didn't meet it, you're in breach. Next, the Divisional Court was wrong at paragraphs 66 and 72 to treat the theoretical possibility.
Sorry, you're going to have to start that sentence.
Yes,
again.
of course.
I need to write it down. The Divisional Court was wrong at 76.
Paragraphs 66 and 72
Yeah.
to treat the theoretical possibility of a viewer obtaining his or her news from just one RT programme as justification for excluding the relevance of every other programme. There was no evidence before the Divisional Court of the existence of such a cohort of viewers, and Ofcom did not suggest that they existed. And even if there might be a handful of people who watched only one programme, namely the RT programme, that clearly is not the position for the vast majority of the viewing public who would have been aware of the content of other programmes. And our submission is you cannot justify a blanket exclusion of the relevance of the dominant media narrative by relying upon the hypothetical existence of a tiny minority of people who are unaware of what is happening on other programmes. Such an approach cannot possibly be said to achieve a fair balance. Next, the Divisional Court was also wrong to say that if one took into account the dominant media narrative, that would make the due impartiality standard impermissibly uncertain. As I said before, Ofcom never contended that there was any difficulty in identifying what the dominant media narrative was, nor that in general it was too difficult to ascertain what it might be. And indeed, Ofcom's own guidance, which I will take you to, makes clear that there is no difficulty in working out what is, quote, the established view of the majority, close quotes. And as I've already mentioned, that's what the New Zealand Code realistically takes into account.
So would the dominant narrative by itself be sufficient to justify RT broadcasting whatever they wanted without seeking to provide balance in other programmes?
The risk of fudging the answer to that question, my lord, I don't have to go that far, because in this case, and I want to emphasise this, we don't say that any of the programmes fail in the content of themselves in some terrible way to make any reference to the other side of the argument. If my lord is asking me, in the most egregious case, could a broadcaster say, well, yes, we said absolutely nothing that referred to the other side of the argument, but because all the other channels were making the alternative viewpoint known, there is no breach. I think the logical extension of my argument is that I would have to go that far, but I don't have to go that far in this case. The final main error concerns the divisional court saying it was permissible to ignore other programmes broadcast on the same channel, namely RT, because without an express editorial link, there could be, and I quote, no guarantee that a viewer would look at the other programme. And we say that is an illogical approach. An editorial link at the end of a programme to say another programme in the series same time next week is obviously not going to guarantee that the viewer turns on the TV the same time next week and watches the other programme. Indeed, in our submission, it is, as a matter of common sense, no more likely that he'll tune in this time next week than he will stay tuned that evening and watch the news 10 minutes, half an hour.
There's no guarantee anybody will watch anything, whatever you say. There's no guarantee anybody will watch anything,
Indeed.
whatever you say. But they're more likely to watch it if you mention it than if you don't.
I accept that.
Yeah.
But that's not a reason to say that the divisional court and indeed Ofcom turn around the guarantee point on its head and say you can guarantee somebody will watch a programme that's linked, and that's a reason to exclude the content of every other programme. But you can't guarantee they'll watch any other programme, whether it's half an hour later, 10 minutes later, or the same time next week.
I mean, are you assuming, for the purposes of this argument, that due impartiality in the regime means due impartiality within the programme? I mean, that's what it means, although maybe you're right in saying, without prejudice to your right to argue that other programming is relevant to that question.
So I'm not sure. I'm not being deliberately obtuse. I'm not sure.
Well, the point is that the starting point is that Ofcom says, and the divisional court says, that the requirement of due impartiality in the statute and in the code is to be taken as meaning due impartiality within the programme. In other words,
Unless it's linked.
Unless there's a link.
Yes.
Yeah. And you are assuming that's right, but saying that in context, you also have to look at other matters when answering the Article 10 question.
Well, my lord, certainly in answering the Article 10 question, we do submit you have to look at other matters. But even in relation to the programme itself, our submission on ground one is that even as a matter of statutory construction, independent of Article 10, there's nothing in the Act or the Code which stops the regulator taking into account non-linked programmes.
But there isn't a question about statutory construction for the regulator. There's only a question under Article 10. I mean, the regulator, of course, has to get the statute correct.
Yes.
But the regulator doesn't sit there solemnly and say,
No.
I'm now trying to work out what the statute means. The
No.
regulator asks itself the Article 10 question.
Yes.
And in the Article 10 question, as I understand it, you say there are certain specific things it can take into account, should take into account. The Divisional Court said it shouldn't. And I've put to you already that I don't see why those artificial lines are to be drawn. But I think you're accepting that Ofcom was entitled to think that due impartiality provision was about the individual programme or linked programmes, which are what is mentioned.
I'm
Linked or adjacent.
yes, in relation to the content of other programmes on other channels, the divisional court found that as a matter of ordinary statutory construction, before one got to Article 10, those were excluded from consideration. To use the phrase of Lord Justice Laws in a case called Khatun, they are excluded by the statutory lexicon. Contrast the position in relation to other broadcasts on RT itself, where there is a live issue before you get to Article 10, this is ground one, as to whether the statute confines the due impartiality analysis to looking at just that programme. I hope that's helpful. Can I deal with one last point as part of my summary on Article 10?
The previous one was the final main error, so how can you have another one?
It's a defensive point rather than an offensive point. Although it's common ground that Ofcom's decisions interfered with Article 10, there is a suggestion in my learned friend's skeleton, paragraph 69A, reflecting part of the divisional court's reasoning, that there isn't really a significant interference with the right to free speech in these cases. Because RT can say whatever it wants to say,
Yeah.
so long as the alternative view is given adequate weight. In our submission, that is a bit like telling somebody on Speaker's Corner, you can shout all you like about the socialist revolution, so long as you tell your listeners that the Tories have got some very good points as well.
Well, your point is that it's as much a restriction on freedom of expression to tell someone they've got to say something as to say they can't say
Exactly so.
what they say. Yeah.
So your analogy is not quite right, is it? Because in your analogy, the speaker is being required to endorse the competing point of view, and don't think that you're arguing that that's what is an issue here.
Perhaps I ought to rephrase it. But you can call out all you like for the socialist revolution as long as you say that some people might think that the Tories have got some very good points.
Other policies are available.
Other policies are available. Here's what they are. Here's what other people say are their merits. Make Speaker's Corner a rather more anodyne place than it at least used to be.
Well, it's about reporting, isn't it? It's not really evaluating at all the existence of the dominant media narrative, as you call it, was on Ofcom's finding not identified to the readers or the viewers of it. Wasn't a question of whether it was mentioned but not given sufficient weight or.
Well, I'll show you what Ofcom said in relation
Yes.
to the decision.
No, I've read that, but it's not. The criticism that they make is not that you didn't endorse or approve it.
No, it's not. It was not presented with sufficient weight. So, for example, one of the programs I'll be taking you to, the program included as one of the panelists somebody called Ambassador Murphy, a former US ambassador, who was asked a variety of questions and gave answers that broadly reflected the US foreign policy approach in Syria. And Ofcom complained that the interviewer, Peter Lavelle, on the Crosstalk programme, effectively interrupted him too often and didn't allow him sufficient space to get his views across as fully as he could have done. So that's not Ofcom saying you, RT, ought to have said that the US was right. It was more an interference with the journalistic freedom of Peter Lavelle, saying you should have been a bit more respectful of the US view.
Are we not missing the point here? Article 10.1 says everyone has the right to freedom of expression.
Yes.
And this right includes freedom to hold opinions, to receive and impart information and ideas without interference by public authority. right?
Yes.
Now, the question here is whether Ofcom has interfered with the freedom to hold opinions and receive and impart information and ideas. And the answer is it accepts it has, because it has exercised its regulatory powers to fine RT for its programming, for expressing opinions. And so that's what it's done. It's not a question of what it said precisely, or how in an ideal world RT could continue to broadcast George Galloway or Peter Lavelle without being the victim of, I can put it that way, of the regulators. The article is infringed because their freedom of expression was brought upon it regulatory interference.
I respectfully entirely agree.
Yeah. And so we mustn't confuse it with what might have happened if they hadn't been regulated, if I can put it that way.
My lord, yes.
Regulatory oppression, as we can call it. I mean, regulators, that's what they're there for, is to interfere. But in this case, they shouldn't, if unless they can get out of it with 10-2.
I respectfully agree.
Okay.
Can I now deal as quickly as I can with the factual background? I'll come on to the breach decision.
We've read a lot, Mr. Krasinski.
You've read a lot.
We read a lot.
I will be as quick as I can. You will recall that the Ofcom investigation started shortly after the Skripal incident. The Skripal incident took place on the 4th of March 2018. On the 12th of March, the Prime Minister makes his speech in Parliament saying that the government holds Russia responsible, and within a few days, Ofcom, which is notionally independent of government, announces its investigation into RT, which it describes as an intensive investigation. 10 programmes are investigated, 7 of which are ultimately found to be in breach. 6 of those 7 are the subject of the present appeal, of which 4 concern Syria and 2 concern Salisbury. Of the 6, only 2, are the subject of any viewer complaint at all. My Lord will know that sometimes Ofcom is flooded with complaints about things, about programmes. Of the 6, 2 were the subjects, I think, of a single viewer complaint. The remaining 4 were not, and were just picked up as part of the intensive investigation. And for your note, a useful summary explaining all of that, and I won't ask you to turn it up now, is at Core Bundle, page 265, in the table under paragraph 40. The breach decision is at Core Bundle tab 18. Do my lords have electronic tabs?
Yes.
It runs to 190 pages, slightly over 190 pages. It's structured in 2 parts. The first, where Ofcom makes a number of general findings applicable to all the programmes, and the second, addressing the content of each. The first starts at page 318, and it records the factual and the investigative background before recording RT's submissions. I'm not going to go through all of those because they largely mirror what we've said in this appeal. Can we get then, please, straight to the Ofcom decision on the general factors, starting, it starts at page 333, but we can go straight, please, to page 335. If you pick it up by the lower hole punch, the sentence starting with...
You know we don't have hole punches on the screen.
It's the paragraph 3rd from the bottom, starting with the words "the code."
They all start with the code. The code containing, or the code...
code
And Ofcom's guidance.
Ah, good.
If my lords just read that paragraph,
Yep.
I'm not going to read it out. And then the bottom of the page, if my lord could read that paragraph.
For each of the 10 programmes?
Yes.
Yeah.
And then over the page, under the heading General Contextual Factors, second paragraph, if my lords could read the 3 paragraphs starting in our view.
You have to read the whole of the general contextual factors. Really.
Yes, indeed. This is central to the decision.
It is central to the decision, the next 2 pages.
It is, and I anticipate.
It's helped you. I've studied it quite carefully.
I'm grateful. In that case, I'm not going to do anything more than make one observation about it. On page 337, penultimate paragraph.
Yes.
The one that starts, the licensee argued that in many of these programmes, as the dominant media narrative was widely disseminated. The point I want to make, which I've already foreshadowed, is that Ofcom has not here said, well, the licensee has argued that the dominant media narrative was widely disseminated by most, if not all, other media outlets and broadcasters, but we don't agree, or we can't work out what that media narrative was. That's the only point I want to make. Can I then...
You'd have to have a tin ear if you didn't know what the dominant media narrative on this issue was.
You would indeed.
Yes.
If
you lived in the UK.
If you lived in the UK. The second part of the decision starts at 339, deals with each of the programmes. I'm not going to deal with all of them, of course. We need to go to some key passages. First of all, to correct a mischaracterisation about the content of the programmes that is found in Millennium Friend's written argument and indeed in the Divisional Court's judgment, and then to illustrate some general points. Mr. Kennelly's skeleton starts at paragraph 1 by saying that each programme affords, and I quote, vastly preferential weight and credit to one particular perspective on the controversial matters addressed. The Divisional Court went even further in paragraph 11 and said that RT had accepted that the programmes were partial, looked at on their own. But we have never accepted that, and I need to make that clear, because it's an important point. Could you take up the supplementary bundle, tab 15, page 338. This is one page of the transcript from the hearing below. Right-hand column of the page, line 3, recording my submission. I'm going to make some observations about the content. First of all, to correct a mischaracterisation of the fact in Ofcom's written arguments, and secondly, to illustrate some broad themes. So I was doing there what I'm going to do today. I then quoted from Ofcom's summary grounds of resistance, where they characterised the programmes as giving vastly preferential weight, and at line 17, the submission was made by Ofcom that we didn't suggest otherwise. And I said at line 19, well, I'm going to show you that we absolutely do suggest otherwise. And the President asks me, what part do you suggest otherwise? And I said, I'm going to show you that when I take you through the programmes. The President says, you're not disputing partiality. And I say, we're not disputing that more weight was afforded to one perspective on the relevant dispute than another.
Sorry, I've not got that. You're not disputing more weight was afforded to one perspective. We're not... Oh, I see, I've got it. Yeah, sorry.
We're not disputing that more weight was afforded to one perspective on the relevant dispute than another, but as Ofcom repeatedly stressed in this case, and indeed in their guidance, due impartiality is a flexible concept and avowedly does not require equal weight to be given to both sides of the argument. And how much weight has to be given and whether there's been a breach of due impartiality is a matter to be taken into the matter to be taken in the context of all the factors we've identified. So we, in answer to the question from the President, are you accepting that the programmes taken on their own are partial? We said no. And yet the Divisional Court, in its judgment at paragraph 11, said we'd accepted precisely that.
I mean, did you point to any particular item in any of the programs
Yes.
and said, this is the balance?
I did then, by reference of the same programs I'm going to show you right now.
Right, okay, good. Because there was, I had the good fortune to watch these programs, and there was an element of sarcasm.
Absolutely.
So if you looked at a transcript, you might not get the full benefit of it.
Yes, I entirely accept. We thought carefully about whether to take time today in showing you programs. But
Well, we love television here.
Sorry?
We love television and theatre. We get both.
I entirely accept that, in part, the tone of a presenter is not captured on a transcript. The divisional court, like my lords, did watch the programmes. We've all watched the programmes. And I also accept that in certain places, particularly, and this is not to criticise him, but no. Mr. Lavelle adopted in parts a sarcastic tone. I mean, that's not confined to RT. No. It happens on Newsnight on a not irregular basis. If a politician is saying something that the presenter doesn't think much of. But as the case law makes clear, particularly the case of Gaunton in the United Kingdom, Article 10 protects the right of journalists to ask things that are sarcastic or even provocative or even sometimes exaggerated.
No, but it may or may not be balanced.
Well,
it may or may not be impartial.
But my lord will appreciate that even on Ofcom's own guidance, an correct understanding of the due impartiality requirement, it does not require balance.
No. Well, what is required is due impartiality, and with an emphasis on the word due,
yes,
as explained in that definition.
Yes.
And I think it's right to say, but I'd like you to correct me if I'm wrong, because Mr. Galloway is also sometimes sarcastic in the programmes we've watched. And if Mr. Galloway, I'm going to give you an example now, this is not what he said. If Mr. Galloway said, the Prime Minister says that Mr. Putin poisoned Mr. Skripal, that is complete rubbish, or without foundation. Does that provide the necessary due impartiality by stating the opponent's view or not?
I mean, it's difficult to, I'm not avoiding the question, it's difficult to answer the question because that won't be the sole, the beginning and the end of a programme.
No, but...
You have to judge the programme in the round.
Okay, but bear in mind that question when you show me what you're going to show us about the programmes themselves.
I will do that. Can I start, please, with the news programme of the 18th of March at page 459. And again, conscious now that you have watched all the programmes, I'm going to take this as quickly as I can.
Well, I mean, we should be clear about that. I
haven't yet, but I will.
But my colleagues didn't have the relevant stick, but they have now been furnished with it, and they have assured me that tonight will be
viewing night,
RT night.
TV dinners.
It's not. It's Bake Off tonight, so after Bake Off.
Okay, that's all right.
That's a popular programme.
I won't make a pun in the Bake Off. Yeah, in the Bake Off. I won't bore you with the joke. Kretinsky is a firm of kosher bakers. My wife.
Well, I'm interested in bakers too, obviously.
My wife's name is Baker. My mother's name was Feinkuchen. There was lots of baking jokes. Anyway, enough personal stuff.
Better move on. I think the Lord's had enough of Bake Off jokes.
Yeah. Can we start, please, at page 459? This is the 18th of March programme about Syria. During monitoring, we assessed a news item in the above programme that reported on the Syrian conflict. A news presenter started the item with a caption. There was a caption of Ghouta, footnote 146. Ghouta, at the time of the broadcast, eastern Ghouta in Syria was an enclave that had been controlled by the Syrian rebel factions by saying. And then there's I'm not going to read it all out. There's quite a lot of commentary about essentially how the Russians had created a safe corridor to allow civilians to flee, it is said, flee from militants shelling the corridors or shelling the area. And over the page, 460, 2/3 of the way down, there's a line that starts, the news presenter, with a caption toxic pretext, then said, meanwhile militants are preparing to stage chemical attacks in the country to give the US a pretext to attack the government, that's the Syrian government. That is according to Russia's defense ministry. And then there's a quote from the RT correspondent Murad Gazdiev, who was standing outside the Russian defense ministry, and says that, or records that, representatives of the Russian armed forces have said that they have information, reason to believe.
I'm sorry, I've lost you.
It's the last indented passage on 460.
Ah, yes.
If my lords could just read that italicised passage.
The representatives of the Russian armed forces.
Yeah. So in a nutshell, that's the Russian perspective, saying these chemical attacks are being planted as a pretext to allow the US to intervene. And there's more of the same. And then if you turn over to page 461, towards the bottom of the page, there's a line that starts, footage was shown. Footage was shown of Nikki Haley, the US ambassador to the UN, speaking at the Security Council in New York. Quote, we also warn any nation that's determined to impose its will through chemical attacks and inhuman suffering, most especially the outlaw Syrian regime. The US remains prepared to act if we must. In the past 16 days, there have been 3 separate allegations of chlorine gas attacks, i.e. by the Assad regime, contrast the rebels. So the programme here is making clear the US view that it was the Assad regime and not the rebels who had staged the chemical weapons attacks. And then over the page, please, middle of the page, passage starting with the word footage. Footage was shown of tanks driving along ruined streets in eastern Ghouta, while the news presenter in a voiceover said the following, with the caption, US pushes the UN to demand a 30-day ceasefire in militant-held Ghouta. The US envoy, strangely enough, pressed the Security Council to demand a 30-day ceasefire in eastern Ghouta, which is where government forces and Russian forces are currently battling terrorists. Nikki Haley then unleashed a barrage of accusations against the Syrian government. Footage was shown of Nikki Haley speaking at the UN Security Council. This is no ceasefire. This is the Assad regime, Iran and Russia continuing to wage war against their political opponents. And then there's a clip where the Russian ambassador basically says, Nikki Haley keeps on blaming the Russians, and I've counted 23 times her blaming the Russians, and there's a sort of supposedly amusing clip of Russia, 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 Russia. My lord might recall it. And then if we go straight, please, to page 469, which is the decision. Could I ask my lords to read from the heading, the preservation of due impartiality on that page, to the end of the first paragraph on the next page. I won't read it out.
Sorry, just tell me again. The last paragraph on 469.
No, the last 3 paragraphs on 469.
Yes.
And the top paragraph on the next page.
Yeah, thanks.
And again, I want to make one point about the passage you just read, the last passage you just read, and it's mutatis mutandis, the same point I've made before, namely that where they recalled my client arguing that as the dominant media narrative was widely disseminated, it wasn't necessary for the news programme to repeat the perspective explicitly. Again, they don't deny that that dominant narrative existed, that narrative being the US intervention in Syria was justified because of the Assad regime's conduct of its administration. I'm paraphrasing. And again, I make the point, briefly because I've made it already, that nowhere did they say, well, look, this is what was said in the programme, and viewers are going to be misled by this because ABC. On the contrary, if you look at page 471, right towards the bottom of the page, third paragraph up from the bottom, it says, we acknowledge that the programme did reflect, to some extent, the viewpoint of the US government by the inclusion of 2 extracts of footage of the US ambassador speaking at the United Nations Security Council. However, we consider that overall, the US government's position wasn't given due weight. For example, the news presenter used what, in our view, was dismissive language to describe Ms. Haley's interventions at the UN. And I think the dismissive language is the reference to the word strangely enough in the next.
Well, that's my point, isn't it? I mean, that's the sarcasm, if you like. But isn't your? I thought your point was going to be a different one, which is that there is no analysis of the harm caused by this treatment. That's
the point I made a few moments ago, and perhaps I didn't say it clearly. That's exactly the point. Well, I'm making.
It sets out your. I mean, you say, as I understand it, it sets out the points you've made.
Yep.
Fairly. Says you've made them. Doesn't say they are obviously wrong in the sense that there was no dominant media narrative. And then says, but we think there is no due impartiality. So is your point that it's not really answering the Article 10 question?
Precisely so. And they refer to Article 10, but they're not answering the Article 10 question. And they're not answering the Article 10 question by saying to themselves, well, actually Article 10 protects the ability of journalists to analyse matters in the way they choose to, including by using language that's less than complimentary, see Gaunt. And with all that in mind, and the great protection afforded to that kind of journalistic freedom, what possible harm is being done by this programme that justifies?
Aren't they? They're analysing the statutory and regulatory regime and its application in this case with Article 10 in mind. It's not as if they come to this as a pure Article 10 question without regard to the statutory regime.
My Lord, they certainly say over and over again, we have taken into account your Article 10 rights.
Yes.
But there's a
two
world
different things, aren't there? I mean, very, very often one has a statutory or a common law context which guides the decision making. And Article 10 has to be taken into account in the way that you apply it.
Yes.
But it's not just, well, let's cast that all aside and ask ourselves the Article 10 question.
No, but given that due impartiality is a flexible concept, our submission below, and to Ofcom and here, is that before you find regulatory interference to be justified by the pressing social need of protecting others, you can't just say, well, the code says due impartiality. We think that actually there was some dismissive language used here and more weight should have been given to one side than was given. Ex hypothesi, we find regulatory interference to be justified, because that just doesn't answer the question. You can say all you like that you've taken into account Article 10. If you don't actually analyse the harm question, it's not substantively meeting the obligation.
The difficulty is actually how you do evaluate harm if you are comparing levels of impartiality. I mean, it's a bit strange we've got 10 programmes here, 3 they acquit, and they're not, I mean, we haven't seen them, but they're not, actually I think we probably have if we look through all of them, I can't remember.
I don't know what's on your memory stick, but I don't know whether you have the 6 or the 10.
I think, unfortunately, it was the first thing I did in this case was look at them, and it was a couple of weeks ago, but I think all 10 actually were on it, I'm not quite sure. But I mean, I looked at them all, and I thought, well, how do you say which one of these crosses the line? Because they're all partial. I'm sorry, Mr. Krasinski, if that contradicts your submission. In a sense, anyway, they're all partial.
They're not equal. I don't
They're not
submit for a second.
balanced.
They give equal weight to both sides.
No, it's very difficult, by the way, to give equal weight to both sides, and we know all the arguments about whether mainstream broadcasters do. But so how do you decide if they cross the line when the line is not apparently, is this sufficiently compliant with the definition of due impartiality, but is action needed in the interests of democracy and in order to protect the rights of others? So
The fact that it's a
you
difficult.
seem to be asking the wrong question.
Sorry, is my lord saying I'm asking the wrong question,
No,
or they're asking the wrong question? I think in my submission, they're asking the wrong question, or they haven't answered.
Necessarily asking the wrong question, in a way, because obviously the requirement for due impartiality requires a consideration of whether it is duly impartial. But actually, the Article 10.2 question is action necessary in the interests of democracy in order to protect the rights of others? So
And-
that confluence is nowhere bottomed out, but probably Ofcom will say, well, that's not our job, that's your job.
Well, they would be wrong to say that, because they are subject to the Human Rights Act just as much as this court is, with respect. They have to. I mean, they purport to.
They're a public authority.
They're a public authority. They purport to comply with Article 10. They don't say, well, this is all jolly difficult.
Yeah, I didn't mean it when I said
No.
they'll say it's my job. I think that was glib. What I meant was they may say we are answering that question by analysing the level of due impartiality, and we don't have to say so.
Well, what they're doing is saying, well, we recognise Article 10 is important. They're saying that. But essentially, irrespective of all your contextual factors, due impartiality is and although we say we accept it's flexible, if you've been more weighty on one side than another, and you crossed a kind of line that we think can't quite be defined, but you've been a bit too dismissive, you've been a bit too denigratory, you've given too much airtime to Peter Lavelle and not enough airtime to Ambassador Murphy. Ipso facto, you're in breach. Not.
But surely you accept, on your argument, that even if Mr. Galloway or Mr. Lavelle had said nothing, I mean, even if there wasn't this acknowledgement of Miss Haley's point of view, because everybody knew what the dominant media narrative was, and because of other programming having speeches by Boris Johnson and Miss Haley, you don't cross the line anyway.
Well,
and there is no reason to answer the Article 10.2 question negatively.
If that were the fact, I would be making that submission. But I
You
don't
say the
need
facts
to
are
go.
better.
My facts are better than
Yeah.
that.
But it's another case where it could be said you actually have to, the logical extension of what you're saying does go that far, and that Ofcom would probably say drives a coach and horses through due impartiality.
Yeah. Well, they will say that because they will say that. But each case will still depend on its own facts. There might be a situation in which a programme is broadcast, a news programme or a current affairs programme, on a particular subject, where no attempt is made to convey one side of the argument. And there is no dominant media narrative, or there isn't a sufficiently strong one. Now, Ofcom will say, well, it's all very difficult to work out what it is, although they say that now, they didn't say it then. And if a broadcaster is going to, I'm being slightly glib, take the gamble of saying nothing on the other side of the argument, it's going to have to be jolly confident about its dominant media narrative point, because that won't always be the position. I mean, these are quite extreme cases.
And yeah,
I'm conscious of the time. I'm just trying to see whether I can, given that my lord has read, sorry, has watched the programme, whether I can cut out.
In one way, you know, you don't need to press. This is a good example. Just give us the references to the other example.
Okay. Well, what might be more? Can I? So I'm not accused of only concentrating on Syria and just. I need to grapple with the Galloway programmes as well. Can I do so by reference to a summary of all of these programmes to be found in Core Bundle page 300? So this is an appendix to our Statement of Facts and Grounds in the JR. Annex A, where we went through each programme, tried to give a summary of the reasoning against us, and then developed our submissions on each. So can I, if we just look, for example, at the very first programme, the Sputnik programme, that's the first Salisbury programme hosted by George Galloway. Could I just invite my lords to read paragraph A4.
I read this yesterday, and I was wondering whether we got, because I didn't chase it down, the written representations that are referred to at subparagraph 4 of A5.
Is that at footnote 190? Sorry.
1198, I think it is, footnote 190.
Because of the page limits on bundles, we have not included all the written representations that were...
And because I was asking myself whether we've got the actual content of the other RT programmes that are quite an important element of your submission.
We don't have, for example, transcript of the news programmes where, for example, I mean, can I show you? Is my lord asking about paragraph on page 302, sub 4 on that page?
That's the one, yeah.
Yeah. No, we don't have that in front of you. I'm sure we could get it if my lord were interested. But again, it's not in dispute that on the same day as this Sputnik programme, there was also a broadcast of Theresa May's address to Conservative Party members, setting out the UK government's view on who was to blame for the incident. I mean, this is, I'm going to make this point to illustrate my point about other RT programmes. I mean, my lords may recall that the RT programme perhaps best known for its coverage of the Salisbury incident was the famous interview by the editor-in-chief Margarita Simonian in September of 2018, where she interviewed the two people suspected of having carried out the attack, where she clearly challenged them about their story to have been tourists in Salisbury, and expressed frank scepticism about the credibility of their accounts. And one of the points I will develop, and I may as well make it now, is that that was a well-publicised interview. We say there's nothing in the code and it makes no sense to say, well, you can take into account, when looking at one Salisbury programme, the content of an editorially linked programme a week later, but you can't take into account that famous and well-publicised interview where the other perspective was put.
Well, months later.
In this case, months later, but I'm talking hypothetically now. So let us say, for example, that interview had taken place within a few days or on the same day as a Galloway programme. I'm using it to illustrate the point of principle. There's just one other page I want to show you to illustrate this point on the relevance or irrelevance of linked programmes. It's for the crosstalk programme of the 20th of April. Just to give you the references, it's summarised in our grounds of challenge annex that I just showed you at page 311, pages A25, paragraphs A25 to A28. I won't ask you to read them now. But if we look at the breach decision itself, the relevant page is at 457. Could I ask you to read, the whole of 457 and the first paragraph on 458? I'm helpfully reminded by my learned junior that it's probably a good time to stop for the transcript writing.
Well, I don't take a break for transcript writers, Mr. Krasinski.
Right.
I'm sorry. We haven't had transcript. We'll get it at the end of the day, and I'm afraid they have to make do. We have limited time in this court.
Hopefully there'll be some natural breaks while I ask you to read bits of the papers, which is what I'm doing now.
Exactly. Well, except I haven't been. I've been talking to you. This starts, the United States has rebuilt our friendships.
No, I'm sorry. Page 457, under the heading Due Impartiality in Clearly Linked and Timely Programmes.
Yeah, okay.
And you want us to go to the bottom of...
No, I'm asking... yes, if you can read the whole of that page and the first paragraph on the next page. I'm using this just to illustrate what Ofcom's approach is. So, although that
has to be expressly, clearly linked.
Indeed. So they say if a programme is immediately adjacent, it can be taken into account, albeit given little weight. If it's not immediately adjacent and not editorially linked, it is necessarily irrelevant. And as my lord will recall, the divisional court goes further and says that even immediately adjacent programmes can't be taken into account without editorial linking. But again, I don't want to make my submissions on that now. I'm just using that page to illustrate what Ofcom's approach was. And that, with that, I can ask my lords to put away that long breach decision. And I'm going to now start with the legislation. Authorities Bundle Volume 1. My lords already have, and I'm not going to repeat the point about how things have changed since 1954, but it's as well to look at the 1954 Act just briefly. Tab 3, it starts at page 33. Television Act 1954, the recital to the Act at page 34 says an Act to make provision for television broadcasting services in addition to those provided by the BBC, and to set up a special authority for that purpose. The authority is created by or under section 1.1. There shall be an authority to be called the Independent Television Authority, whose function shall be to provide in accordance with the provisions of this Act, and for the period of 10 years, television broadcasting services additional to those of the BBC of high quality, both as to transmission and as to the matter transmitted. And then over the page, please, section 3, it shall be the duty of the authority to satisfy themselves that, so far as possible, the programmes broadcast by the authority comply with the following requirements. I'm not going to read them all. A is about not offending good taste and decency, probably rather different in 54 than it is today. C, any news given in the programme in whatever form is presented with due accuracy and impartiality. D, another illustration of how things have changed since 1954, that proper proportions of the recorded and other matter included in the programmes are of British origin and of British performance. I'm not sure how you'd square that with the Equality Act 2010. And then F, that due impartiality is preserved on the part of the persons providing the programmes as respect matters of political or industrial controversy or relating to current public policy. So, again, I'm not going to repeat the points about the broadcasting landscape being very different then to what it is now. But I do want to make a point in criticism of the divisional court. Could I ask you, just with keeping the authorities bundle open, just to look at the divisional court's judgment at paragraph 21. Towards the bottom of page 89, within paragraph 21, there's a sentence about halfway down that paragraph in the middle of the line that says, it's not the case, therefore, that the due impartiality requirements were simply carried over into the 2003 Act from previous legislation without consideration of their implications, nor do I accept the passage of time and the technological developments which have occurred since the due impartiality requirements were introduced in 1954 mandates a different interpretative approach or affects the underlying policy considerations. This is because at present, the broadcast media maintains a reach and immediacy that remains unrivaled by other media. Well, whether or not that is correct, and whether or not by 2021, or when this divisional court judgment was given in 2020, TV news has the same potency as it did in 54 or in previous years. That wasn't the point we were making. The point we were making is the one I adverted to before, which is if you've got two news channels, BBC and ITV, it might be thought that a more rigorous approach is called for when assessing compliance with due impartiality, to ensure that the news content of the two channels, BBC and ITV, will broadcast and give weight to a range of opinions, and that a correspondingly more flexible approach is called for now, given the proliferation of news channels. Indeed, back in 1954, the concept of a small channel such as RT, broadcasting views at odds with the dominant media narrative, just didn't exist at all. That's the point we were making below, and we repeat in our skeleton here at paragraph 24. I'm going to ask you to turn to it. And similar points were reflected in Ofcom's own study, supplementary bundle, tab 2. This is a 2007 discussion document published at the time of the changeover from analogue to digital. Paragraph 1 on page 36 just makes the point that the way news is made and used is changing at an unprecedented pace, and one of the drivers was the digital switchover. And then over the page, at paragraph 1.11, page 37, para 1.11, the unprecedented availability of such a huge range of traditional and new sources of news opens up possibilities for real diversity of opinion to be heard. 1.13, the importance of another traditional value in television news, impartiality, may also be questioned in future beyond the public service broadcast channels. Impartiality rules are currently applied to all UK licensed news. There remains broad public support for the notion, but it may be an unintended consequence that rules on impartiality serve to stifle the expression of views that are not part of the established mainstream, to which we respectfully agree. Such as those of the young, some ethnic minorities and others, it arises because news broadcasters may feel compelled to offer a traditional both sides of the argument approach to the exclusion of more diverse voices. So that's the background. The Act is to be found at Authorities Bundle tab 5, 2003 Act. Again, conscious of the time, could I ask whether my lords have had a chance to look at the legislation yet?
In detail.
Well, then I won't go through it all. Can I instead then skip straight to the code, which is in the same bundle at tab 1, starting on page 7, which is section 5 of the code under the heading due impartiality and due accuracy.
I'm just going to make this point because I know your solicitors are here and everybody's here. I make it often. The numbers do not match in the electronic document, the numbers in the bundle.
I'm sorry, that's why my lord keeps on missing my reference.
One of them does, one of the bundles does, but it is not rocket science. And if in future we could have bundles, electronic bundles that match the paper bundles, that would be wonderful.
I'm very sorry, I didn't realise that was the case until just now.
It's all right. Probably nobody's in court is at fault, but it just needs giving very clear instructions when the bundles are prepared.
Well, it may help, therefore, if I use the internal pagination at the top of the code. Does my lord see page 28?
Yes, got that.
So the principle is to ensure that news in whatever form is reported with due accuracy and presented with due impartiality. There's then a rule which effectively has quasi-legislative status, because this is made under the Act, pursuant to Ofcom's obligation to make rules. So this is its rule definition of the meaning of due impartiality. If my lords could just reread, I'm sure you read it already, that important definition.
Yeah.
What happens with the numbering, by the way, is people forget to add...
One.
No, the index. It's the cover page and the index. There are two. These are all two pages out.
2 pages out.
Because there's a cover page and an index.
And obviously, for present purposes, the important sentence that I want to focus on all of it, but the last sentence, context as defined in section 2, is important. And then, so if you turn back to internal page 17, which is...
Just before you do that,
yes,
since you've directed our attention to this meaning of due impartiality with its quasi-legislative status makes it perfectly clear, doesn't it, that it is talking about the programme. It says several times, due means adequate or appropriate to the subject and nature of the programme.
yes.
Doesn't mean an equal division of time has to be given to every view, i.e. in the programme. The approach to due impartiality may vary according to the nature of the subject, the type of programme and the channel. the likely expectation of the audience and the extent to which content and approach is signalled.
I
Context.
entirely accept that,
Yeah.
my lord. I don't for a moment suggest that when answering the question, has a broadcaster satisfied the due impartiality requirement, it can ignore the programme under investigation. It's always centred on the programme. My submission is that in assessing whether due impartiality is met for that programme, context is relevant, and context can include the content of other programmes. So to
This
refer...
is taking us back to 2 then, is it? This is big.
Yes, before I get this, it's an important point. So, as we described it below, and as I think is mentioned in the judgment below, the unit of assessment is the programme. But that is separate from what context can be taken into account when assessing that unit. And indeed, the Divisional Court's cardinal error on ground 1 that I'll come to is that it seemed to think we were saying that other programmes could be taken into account on a stretched definition of series. That was never our case. I'm not suggesting that a programme that immediately follows, if programme 2 is relevant and immediately follows programme 1, or happens to be 10 minutes after programme 1, I'm not saying that falls within the statutory definition of a series. I'm just saying it's part of the relevant context, or maybe. So if we then go back to the meaning of context, which in my bundle in hard copy is at page 3. I don't know if you've got page 5.
Internal 17.
Internal 17.
Yeah, at the top.
Meaning of context. Context includes, but is not limited to, and then the 4th bullet, what other programmes are scheduled before and after the programme or the programme's concerned.
You say you've used the word immediately.
Well, that's what Ofcom said. That's my complaint.
What do you? Yeah. So you say it's not necessarily immediately. It can be.
Could be half an hour later. Could be 10 minutes later. I mean, to use the point that my Lord, the Master of the Rolls, put to me, if a programme is 8 months later, it's going to be very difficult for somebody seeking to rely upon that to do so. If it's 10 minutes later, or is likely to be watched by some viewers, that's a matter to be taken into account. And my Lord Justice Baker is right. It does not say what other programmes are scheduled adjacent to, immediately before and after. Then the degree of harm or offence likely to be caused by the inclusion of any programme, any particular sort of material, or the likely size and composition of the potential audience.
It's quite difficult to transpose this set of contextual factors which appear in the context of harm and offence.
Yes.
Into the separate and distinct context of due impartiality. Because in this context, it's hard to see how something would be less offensive because of something that was broadcast 10 days later. I mean, it's either got to be offensive at the time or not.
Yes. But this non-exhaustive list is not confined to the due impartiality standard. It covers a range of matters. Yeah. Can I...
Well, it's under the heading harm and offence, that's the point. It's in section 2.
It is, but...
And then it's cross-referred to.
It's cross-referred to.
Section 5.
I mean, one way of illustrating why these... Well, can I show my Lord's... I was going to do it later, but I think it's probably worth doing it now. You were sent, I hope, yesterday, and I think hard copies have been handed up, the New Zealand code, which is equivalent. And I just want to show you.
Oh, sorry, we got that New Zealand code yesterday, didn't we?
You did, and you've got some more pages today in hard copy on your bench. Okay, well, I'll just show you what you were sent yesterday.
Show me what
We got the standards, the Part 1 standard.
Yeah. Let me show you what you got yesterday. If you could turn to a page that says Standard 8, Balance. It's in internal page 18. This margin here has a page number on it. If you look for page 18. The purpose of this standard is to ensure that competing viewpoints about significant issues are presented to enable the audience to arrive at an informed and reasoned opinion. The objective of the standard, a well-informed public, is important to the operation of an open and democratic society and is consistent with the principles of freedom of expression. A common sense approach should be taken in applying the standard. We acknowledge the practical reality that programmes can't be perfectly balanced. This isn't required. Consideration of the standard will reflect the present broadcasting environment in New Zealand and the increased flows of information which now pass over us on topics of all kinds. The proliferation of broadcast media which is consciously delivered from a political perspective, and a more discriminating viewing public. Decisions made under the balance standard will always be fact and context dependent to reflect this modern and diverse broadcasting world. The standard also allows for balance to be achieved over time within the period of current interest. A number of criteria must be satisfied before the requirements to present significant alternative viewpoints are triggered. The standard only applies to news, current affairs and factual programmes which discuss a controversial issue. So it's a similar, if not identical, scope to the due impartiality standard in our case. And then on the right-hand column, in determining whether programmes breach this standard, the following factors will be considered: the programme's introduction and the way in which it is presented, the type of programme, the nature of the issue and of the discussion, whether the programme approaches a topic from a particular perspective, whether the programme acknowledges the existence of other views, whether the audience could reasonably be expected to be aware of other views, including in other media sources, and the platform on which the programme is broadcast. The key consideration is what an audience expects from a programme and whether they were likely to have been misinformed, and that's critical, by the omission or treatment of a significant perspective. For example, where a significant perspective is presented with limited coverage or in a manner that undermines its validity. So, unlike Ofcom's approach, which is to say that whether the audience could be reasonably be expected to be aware of other views is irrelevant, and unlike Ofcom's approach, which effectively doesn't assess the question of misinformation at all, the New Zealand approach is far more in line with common sense and far more in accordance with the requirements of freedom of expression. And I need to show you what the divisional court said about New Zealand, because it's, with respect, difficult to follow. The divisional court at paragraph 72, 71, I beg your pardon, said, this is page 105 of the core bundle, paragraph, well, I don't know, I hope it's 105 of the core bundle. Do my pages and your pages of the core bundle match?
Just paragraph would be...
Paragraph 71.
Yeah.
They say, as to the position in New Zealand, the court was not provided with any information about the way in which media is accessed in that jurisdiction by those who also access broadcast media. With respect, that doesn't meet the point I was making at all.
But the legislation is presumably different.
Can I show? Well, if you turn up the physical, I know that my Lord Clerk was given this morning because I saw it being handed onto the bench. The standard itself. We've got another version of it.
Yeah, it is. I've got it.
Okay.
I'm only being ready about not looking at paper.
Let me put the cool one away.
It's not completely a joke. I find it very difficult to read small print.
Me too.
So this is, I see.
So this is the fuller version. You can see the standard at internal page 39.
You will let us have this electronically, won't you?
Yes.
Sorry, which page were you?
39.
39.
Standard 8 balance.
Yeah.
So I read you the guidance, and this is the actual standard.
I see.
Which mirrors the legislation. We can give you the legislation as well.
It seems to be an act of 1989
Yes,
in New Zealand.
yes.
Well, it's clearer because it makes it clear what it's talking about. Make reasonable efforts to present significant points of view, either in the same programme or in other programmes within a period of current interest.
And then if you look at the very bottom bullet on that column, the nature of these, this is one of the factors to be taken into account.
Yeah. I mean, it's always difficult to look at a different legislative regime and get very much out of it
Well,
without studying it in very great detail,
Well,
isn't it?
sometimes it is. In this case, all I'm using this to illustrate is, to the extent it said, well, our approach would be fundamentally inconsistent with the democratic values that Article 10 is there to protect, and presents insuperable difficulties of knowing what the dominant media narrative is and taking it into account. It's difficult to square that with a responsible code in a developed democracy attaching importance to political free speech. I'm not suggesting there has to be a unified standard across all jurisdictions. If we can go back to the UK code, authorities.
The problem with it is it doesn't say dominant media initiative in our legislation or our code, and they do obviously have something that refers to it.
They don't have reference to other media in the legislation. The code does include it. And all I'm
legislation, as with us.
Yeah.
I mean, the problem I've got is that what you're really saying is that you don't need, in this program, you don't need anything but one viewpoint. But that's not really what the legislation or the code is saying. I mean, not our code is saying.
But as I said before, that will often not be the case.
No, I mean, you're saying where there is a dominant media initiative that's different, and it could be different in other cases, but not here. But it's still quite a strong thing to say that where there is, where RT, to take an example, is out on a limb, which perhaps it often would be, and other broadcasters will be out on a limb in other, if we were having a fishing dispute with France, maybe France Telecom, whatever they call it, France 24 would broadcast stuff that was anti-British. Well, and British broadcasting would broadcast. I mean, the point is, the regime is about the programme. That's what troubles me about your submissions, Mr.
But I think the regime is about the programme in New Zealand too. It's just what can be taken into account in adjudicating whether the standard is met. And I accept that it's a strong submission by law, but Article 10 provides strong protection. And if you are having to read a flexible view impartiality standard consistently with only interfering with freedom of expression where there is a pressing social need for the protection of the rights of others? You have to ask yourself that question. And if the answer to that question is, well, there is no harm done, no one is being misled by these programs, because everybody knows that the dominant view is the Russians did it, it's not that ambitious an argument to say you don't need to repeat it, or you don't need to repeat it with much weight in the program. And after all, the Galloway programs, for example, don't say the Skripals have been poisoned, the only candidate is Porton Down. They mention Porton Down, you may recall. They say, look, everyone is saying it's the Russians, so there's the acknowledgement of one side.
Porton Down is only 7 miles away.
Porton Down is only 7 miles away. They're not saying there is only one story. They're saying that's what everybody else is saying, and here's the reason to question it. So we're not in a situation where there is a story where only one side of the story is given. Rather, we're in a situation where there's a story where more weight is being given to the skeptic, the Russian skeptical view, set against the background of everybody else saying something different.
Maybe I should ask Ofcom this, but how often are there such determinations, breach decisions in relation to broadcasters? I mean, I'm just thinking whether this is sort of an isolated incident or whether this happens all the time in relation to mainstream broadcasters as well as...
It does happen. I mean, certainly it happens in relation to mainstream broadcasters as well. Channel 4, I mean, I remember... It's not a highly unusual occurrence.
I mean, just quickly, Mr. Kennedy.
I'm taking instructions.
Oh, okay. Okay, no, come back.
Here, they can.
Yeah. It does happen.
It certainly happens, and not irregular.
Just following through your argument about dominant media narrative,
Yes.
does it follow that the more dominant the media narrative, the more latitude must be allowed to you as to the interpretation of due?
Precisely. Because, and can I just emphasise this, that the code itself says, could I ask you to remind yourself of it, that due can sometimes mean saying nothing at all. And we can see that from the definition. Due impartiality does not mean an equal division of time has to be given to every view, or that every argument and every facet has to be represented. That is emphasised in the guidance to the code. If you turn, please, to the guidance at paragraph 1.10, which in my bundle is at page 15.
I'm sorry, I didn't get the page.
It's my 15
Of what?
of the joint authorities bundle.
The authority. 15 in the bundle.
15 in the bundle, paragraph 1.10.
Yeah. Yeah.
So this is Ofcom's guidance on its own code.
Hmm.
Rule 5.1 is potentially applicable to any topic included in news programming and not just matters of political or industrial controversy. There is no requirement on broadcasters to provide an alternative viewpoint in all news stories or on all news or all issues in the news. So to go back to my Lord Justice Baker's question, when will it not be necessary to provide an alternative view? Answer, sometimes, when that view is being shouted from the rooftops from every other news channel.
I mean, there are a lot of stories which involve Russia which don't get much media coverage in the mainstream media.
Yes, which is why I said before, it won't be always possible for a broadcaster to rely upon the dominant narrative because there may not be one. And then if there isn't one, they can't rely on it.
Or there may be a dominant media position, but only in certain outlets. So, for example, broadsheets, or FT may be publishing articles which the tabloids wouldn't publish.
Yes, and again, it would be a bold submission for RT to say, well, because I found this particular perspective aired for 10 minutes on Fox News, that makes it the dominant media narrative. But as my Lord the Master of the Rolls said, for these programmes, you'd have to have a tin ear and a tin hat not to be aware of what everyone thought who was to blame for the Skripal poisoning.
So in evaluating the degree of impartiality which you're required to demonstrate,
Yes.
does RT have to consider the extent to which there is a dominant media narrative?
Well, if it wants to rely upon it to say we are not in breach and you shouldn't be interfering, you shouldn't be telling us. We're a Russian TV channel. We avowedly have a different take on news. Our audiences know that. Before you, the regulator, start telling us what we can and can't say on an important matter of political free speech, we are entitled to take into account, and you must take into account, what everybody else is saying. So
and I imagine that RT is adopting the same approach to all its programmes, whether in terms of, does RT change its approach to impartiality, depending on the narrative?
I mean, I don't want to criticise anybody, but just as Ofcom doesn't sit through every decision as a matter of statutory construction, I very much have every editor always thinks to himself what the position is in terms of the dominant narrative. But that's not the test. The test is Ofcom entitled, corresponding to a pressing social need, to penalise a TV channel for what it has said on its programmes? And if the answer to that question is no one's being misled because everybody knows what most people are saying, the answer is no.
It's actually been penalised for what it was not saying.
Penalised for what it was not saying, or not saying loudly enough.
Yes.
You know, for denigrating Ambassador or interrupting Ambassador Murphy, or using footage that rather ridiculed the US ambassador to the UN, Ambassador Haley. Just while we're in the...
You never know if nobody is being misled, do you? I mean, this is the question of the
You
cohort.
never know if nobody's being
Sorry,
misled.
but you never know whether people are being misled or not. I mean, there will always be some.
Well, of course it's possible, but if you're judging the proportionality of a general rule, you've got to look at the generality of the population. You can't just say, well, there might be one, and this is essentially the divisional court's approach. Well, there might be one person who might watch one RT programme, as a result of which he might be deluded into thinking that there's no way the Russians did it. And I'm saying that can't be a lawful approach to justifying the exclusion of the dominant media narrative for whom the majority will have access and will watch. Because most people, almost nobody's going to be misled. The fact there might be one person that's misled is not enough.
Well, you've just said that we're assessing, or you're inviting us to assess the proportionality of a general rule. But your way of crystallising issue 2 was tied to the decision on the facts of this case.
It is. So
and that must be the right. We can only complain.
The overall question. The overall
by
question.
focusing on the individual decision.
Indeed, the overall question for every programme is: did Ofcom properly analyse whether any harm was caused? That's a fact-specific, context-specific question. The general question is: can you, within that analysis, have a blanket rule that says you will never take into account the dominant media narrative? That's a general question, and it's one that we say Ofcom and the Divisional Court went wrong on. Just picking up the guidance on the same page as we were looking at a moment ago, paragraph 1.12, in reporting on particular news items, the broadcaster should take into account of all relevant facts, sub silentio, unless it's the dominant media narrative, including the nature of the coverage and whether there are varying viewpoints on a particular item. For example, if a news item includes criticism of individuals or organisations, then broadcasters should consider whether they need to reflect the viewpoints of the individuals or organisations being criticised. So it's a flexible standard. And then, please, carrying on in that bundle, if you turn to page 20, paragraph 1.32, same point under the guidance to Rule 5.5, bottom of the page, last 4 lines. The preservation of due impartiality does not require a broadcaster to include every argument on a particular subject, or to provide in each case a directly opposing argument to the one presented over the page. It will not always be necessary to present an opposing view which is at odds with the established view of the majority. I mean, that seems to be saying, A, there's no difficulty in working out what the established view of the majority is, and B, once you've worked out what it is, you don't have to present an alternative view. But if you don't have to present an alternative view to the established view of the majority, why do you have to present the established view of the majority when you are presenting the alternative view? And that's a rather convoluted sentence, but it's essentially turning 1.33 around and saying what source for the goose is source for the gander. If you don't always have to present argument B, because argument A is the established view, surely, if you are broadcasting the minority view, it can't follow that you have to broadcast the established view. But that's the effect of Ofcom's decision.
Well, this raises something that's troubled me about this case, really, is that the view on one analysis, and I know your clients would completely reject this, but the view on one analysis is that the programming in this case was quite extreme, right? It was quite unusual, anyway, to the UK ear. But we are told in both sides' argument that everybody's entitled to say what they want. There isn't free speech demands that you can have extreme views, provided they're not harmful and violent and this kind of thing. So we shouldn't really be taking into account how extreme or not the view was, because it's a view and it's entitled to respect under Article 10. But one can't sort of help thinking that the argument somehow, but without saying how, does take into account the extreme nature of the opinion. And I suppose this is your point about 1.33. 1.33 says if you're expressing a mainstream view,
You don't have to say anything
you don't
different.
really need to worry. But if you're expressing an extreme view, you do need to worry. But what I find difficult, I still find this difficult, and as you've been talking, I come back to it every time, is that when you ask the real question under Article 10, how does that fit in? The real question, namely, is it necessary in the interests of democracy and in order to protect the rights of others? How does that fit in with the due impartiality regime and the need for balance? Because actually, Article 10 is asking a question about is action needed, is intervention needed in the interests of democracy and to protect the rights of others? I mean, the others are viewers. Why is a program that has a little bit of maybe slightly cynical balance doesn't need to be intervened against, and one that has nothing does need to be intervened against?
Oh, I wouldn't dissent from any of that.
Well, I mean, I'm asking the question.
But if the question is, how do you square that with a statutory imperative to achieve due impartiality, the answer is twofold. One is that, as Ofcom recognised, the concept of due may mean giving no weight at all to one side of the argument, not saying anything, if, for example, they say there's an established view. You don't always need to put the alternative.
I mean, Ofcom could be wrong, but this is part of the code.
This is part of the. No, to be fair,
No, this is
guidance on.
Yes, sorry.
So it's not delegated. It's not quasi-legislation. It's guidance on.
No, sorry.
Yes. So I'm making a forensic rather than a statutory point.
Yeah. Okay.
But the other answer to my Lord's question, it comes when we get there later today, based upon the very strong interpretative obligation in Section 3 of the Human Rights Act. You will have been shown Gaydan and Godin Mendoza many, many times, and you will recall the speech of Lord Nichols, where he said you can change the meaning of legislation to make it convention compatible, provided you don't go against the grain of the legislation. You can read in words, you can excise words, and you can certainly interpret due impartiality with sufficient flexibility to allow it to take into account the dominant media narrative and the content of other RT news programmes. That's not a whole. That's why we don't have to have a wholesale attack.
So what's the position if there is no dominant media narrative on your analysis?
Well, then you don't take it into account.
But then what? Then you, in every case, 133 is wrong, because if you're even expressing a view that is not the dominant media narrative, but is a clear view, there must be some statement of the opposing view.
Well, I don't concede that, my lord. Again, it's all context specific.
Because I'm always worried about taking a decision based on the facts of the case, which has very severe ramifications for the future in other cases. Ofcom has to regulate everybody,
Absolutely.
not just you.
Absolutely. I recognise the importance of this issue, and what will come from this court by way of its judgment will affect my client and Ofcom and all of the other broadcast regulated entities.
I mean, it's a sort of simple view, isn't it, that you do actually have to state the opposing view, and if you don't, you haven't satisfied due impartiality, but you don't have to do it 20 times.
But although this paragraph of the guidance is not quasi-legislation, the definition in the code of due impartiality is quasi-legislation, and that says due impartiality does not mean the equal division of time has to be given to every view or that every argument has to be presented. So it doesn't always require.
Well, not every argument or every facet of the argument, because that's just common sense. But when it says does not mean every argument, it implies that another argument does need to be presented.
Now, I'm not sure how much further I can take this part of the.
No, I mean, but it's terribly important.
It is terribly important.
And interestingly, the meaning of due impartiality itself, and it's something you haven't really mentioned, except to point it out, is that it includes the likely expectation of the audience as to content.
Well, I'm going to come to that very, very squarely, because that was part of our submissions below, and to Ofcom, and here in our skeleton, is that people know what they're watching when they watch RT. RT makes no secret of the fact that it's presenting a Russian perspective. Its strapline or tagline is "Question more." In other words, always question what's being said by others. A lot of the content is produced in Moscow. You get newscasters standing in front of Red Square or the Kremlin. No one can be under any illusion that they're getting anything other than a Russian perspective. And it's true that the Ofcom decisions recite, yes, we know all that, and we've taken it into account. But what they never do is ask themselves the question again, well, given that everybody knows this is a Russian channel broadcasting a Russian-centric view, is anybody going to be misled into thinking ABC?
I mean, is the misleading the key question? And if so, why?
Because it's for the prevention of harm. I mean, can I show my lords sort of find two paragraphs. Give me a moment. Can I ask you to turn to the core bundle, tab 13? To show you the consistency in Ofcom's approach. This is tab 13, Ofcom's skeleton argument, paragraph 33, which in my bundle is at 195. Paragraph 33. Parliament's objectives in enacting the due impartiality requirements concern a potential danger to democracy where broadcasters permitted to offer a one-sided perspective in relation to news and controversial matters of public interest. An assessment of whether in any particular case, this is a case-specific question, findings of breach strike the requisite fair balance between individual rights and societal rights requires the consideration of two things. First, the harm which would be caused to specific viewers of the broadcast as a result of their exposure to partial broadcasting or matters of important political and public interest. And the same point is made again in Ofcom's skeleton in this appeal. I'll give you the reference in a moment. But my point is, what harm is there that can be, that viewers are being protected against, other than the harm of being misled? If you're exposed to...
Yeah, I'm sorry to be difficult about harm, but where is the harm, the test of harm mentioned in either authority on Article 10 or in the Code?
In the Code, it's mentioned in...
well, it's Section 2.
It's Section 2.
Section 2 is not directly to do with Section 5. So, I mean, of course, everybody is concerned with harm, but not, I think, as in the Article 10. I mean,
well, my lord, just give me one moment.
The question is whether action is necessary to protect the rights of others. I mean, nobody has suggested any other part of Article 10.2 is relevant. And, you know, actually the context of the rights of others is quite interesting.
Well, indeed. But what right of the audience is Ofcom seeking or saying it's protecting, other than the right of an audience not to be misled?
Well, I don't think it's... I mean, I think harm and misled are sort of part of it, but I think it's... Personally, I think it must be more general than that. It must be that there is a greater good in a democratic society. I mean, I think this is what Lord Justice Dingemans said. There is a greater good in a democratic society for people to be exposed to balanced news coverage. And therefore, it is per se damaging, it is per se contrary to failing to protect the rights of others if you give them an undiluted diet of one side. And I think that's as far as it goes. I think that looking for specific harm, you know, in terms of, I mean, why are you harmed by seeing something that's undiluted opinion of one side? You may dislike it, you may believe it when you shouldn't, but it's not about harm. It's about protecting the democratic right. That's why democratic comes first, and then the other things that have to be necessary for.
My Lord, I see that, but there are two answers to it. First, Ofcom itself accepts that you have to have an assessment of harm. It accepted it below, it accepts it here.
Yeah, but we can accept everything, but ultimately we have to say why we're accepting it. I find in public law cases generally that counsel often say, well, this has to be proportionate, and you ask them why, and they don't know. And that's why I'm afraid I question, you know, the sort of a test that doesn't come out of a statute or guidance or has some foundation in authority.
My Lord is right that in Article 10, the only bit of Article 10.2 that is engaged here, because it's not protection of morals or public safety or any of those factors, is the protection of the rights of others, which is the rather inchoate concept.
We're not when taken with democracy.
But you're still protecting some section of society, some people. And if the answer is that I hear what my Lord says about harm, but if the answer is that no harm is done by a particular programme because no one is misled, that must go into the balance in deciding whether the undoubted interference with the free speech right is justified.
But a rule that is designed, among other things, to prevent the dissemination of one-sided propaganda,
yes,
would, in principle, be a legitimate tool in a democratic society.
Agreed.
The next question is, to what extent is it necessary in every individual case to explore the extent to which that propaganda has actually been bought by the people to whom it's directed? You're saying that granular examination has to be undertaken in this case,
yes,
and in any other such case, by reference to the, whatever it is, 300 viewers of RT in this jurisdiction. I would have almost carry out a poll with such a small audience.
No.
Is it only 300?
No, it's several thousand.
1,600.
No, it's more than that.
Yeah, I've got them.
It's some. I'll be given the figure, but it's some number of thousands.
Yes, but a relatively small number.
Relatively small number.
People.
No, I'm not suggesting for a second that Ofcom needs to carry out a YouGov or some other poll, but it can assess for itself the extent to which the democratic discourse has been harmed by or interfered with by the programme. And the answer is, there's obviously a world of difference between a situation in which there is state propaganda across all of the news channels, or for example, I don't know, I'm speculating, but if in North Korea there is only one news channel, you can see the problems with that. But when you have a proliferation of channels, call it 100, 90 of which are saying one thing, is the protection of the democratic discourse a sufficient justification for saying that the last 10 or the last one has to repeat what the first 90 are saying?
So the degree of impartiality expected of broadcasting will vary depending on the broadcaster, depending on the size of the audience, depending on what the audience expects.
But that's precisely what Ofcom say themselves. They say it depends upon audience expectations.
So in other words, the BBC has a higher standard expected of it than RT.
Well, you could put it that way. You could also say, when I switch on the BBC News at 10 o'clock, I might have a different expectation about what I'm going to see and hear than when I switch on Fox News or RT or the French television channel that the Master of the Rolls mentioned. And just as the New Zealand Code recognises, viewers are not naive. They know what they're watching. They know that they'll get something different from Jeremy Paxman or George Galloway or whatever it might be. And our submission, which I don't think is that ambitious with respect, is you just have to take that into account. That's part of the context. as reflected in the code that says audience expectation is relevant.
I mean, I think we're not disagreeing with you that you have to take into account what's in the definition. I think we're questioning how you take it into account if there is no impartiality within the programme.
But that begs the question, my lord. The test is due impartiality. It isn't.
Yeah, but it doesn't mean no impartiality.
It doesn't mean, well, it can mean sometimes, see the guidance, nothing at all, if, ironically, all you're doing is parroting the established view of the majority, if that bit of the guidance is right.
I find that strange in itself.
I mean, and again, it might always be context specific or time specific. One of the complaints of the divisional court was, if I was right, it would make the content of the due impartiality standard change over in what Lord Justice Dingemans called real time. But it does change in real time. I mean, for example, a news item on Brexit in 2016 might have to have something very different to explain the sides of the argument to what it does now. I mean, the world moves on. People.
And does it change with the nature of the story?
It might do.
It follows on from what you said about Brexit. So, was the duty of impartiality, is it greater on RT in cases like the Salisbury poisonings,
Why would
Ukraine?
Well, in my submission,
gas supply to Germany.
Yeah.
These issues which are very prominent.
Absolutely. So to use the last of my Lord's examples, if there was a programme broadcast this evening on RT about the rights and wrongs of the energy crisis now, somebody watching it, if they heard the presenter say, well, Russia's been accused of constricting the gas supply to Europe to create economic havoc, or at least supply chain difficulties, and that's. But here are the reasons why Russia is not doing that. It's the perfectly legitimate reasons for why its gas supply arrangements are the way they are. The viewer will say, and I'm not using the Mandy Rice Davis point, where they would say that, wouldn't they? But the viewer will not be naive enough to think, well, they'll know that they're getting a Russian perspective. They're being told they're getting a Russian perspective. So I'm not suggesting that the due impartiality standard is lower for RT. It's just context specific, and it's driven, inter alia, by audience expectation, as recognised by the code. It can't be inflexible or one size fits all approach.
Right, how are we doing?
Well, I see the time. I mean, to be honest, I've covered a lot of the ground already in the course of argument. It may not have had the structure I might have liked, but I'm making a lot of the points as I go along. But what I have still to do is deal with our statutory construction point on ground one, deal with the case law, which I can probably deal with very quickly, and then pick up any points that I haven't already covered on ground two.
Okay, and you've agreed, have you, with Mr. Kennedy?
We've agreed, Mr. Kennedy, I'll definitely be finished today, and I hope to be finished well before the
We
end.
have to finish at lunchtime tomorrow.
We,
1.5 days.
Well, we were. Can I explain the position with the time estimate, my lord? We both agreed 1.5 days. We then were told that it was 2 days, and we both questioned that. And the letter from the listing office says you've got 2 days.
Well, I haven't.
You haven't, right? I'll speed up.
I'm sorry.
No. I mean, these things happen.
I mean, I don't think we'd have, if I may say so, we'd have asked you any less questions, even if it had been 2 days.
I'll speed up.
I mean, I think we all think this is a very interesting case. So it's perfectly obvious from the discussion, and probably an important case. But we've got detailed written arguments, and we have read the material.
Yeah, I'm grateful.
Okay, 2 o'clock.